build it to sell it, right? Begin with the end in mind, and you'll never regret owning a business that you built to sell. It's going to be more productive. It's going to be more profitable. And frankly, it's a lot more fun to run that business.
Hello and welcome to the Remarkable CEO Podcast, a show dedicated to chiropractors who want to transform their job into a business so that they can have a remarkable practice as part of a remarkable life, not instead of one. With your hosts, Dr. Pete Camiolo and Dr. Stephen Franson.
What's up, Remarkables? Hey, welcome to another episode of the Remarkable CEO Podcast. I'm Dr. Stephen Franson, and I'm joined by a very special guest and a longtime friend, my attorney, John Colucci. Dr. John, I know I'm going to call you Dr. John at least 5 times during the show today. John Colucci, welcome to the show, brother.
Hey, it's great to be here. Great to be here.
So, John, I've asked John to join us today to have a conversation about the legal side of an exit strategy, right? So today we're going to be having a conversation about the remarkable exit process. And as you guys know, we organize the remarkable exit process into 5 distinct phases. The first being your vision, like what does an ideal exit look like for you? The second being your readiness, like are you ready? How ready are you? And how do you get ready? You know, you personally, your identity, you as a leader, you're getting your business ready, your practice ready, your team ready, your patients ready for sale. That's readiness. Number 3 is go to market, like actually taking your market out for sale, whether you're doing that internally, externally, you're doing it by yourself, you're using a broker or another professional, et cetera. And then number 4, which is the transaction piece of this, which is the preparing the deal, right? So it's the terms, it's the contracts, it's the negotiation, the collaboration, the passing of paper, passing of checks, et cetera. That's the transaction piece of this. And then, of course, there's the transition, which is what's life like for you after the sale of the business. John, I'm psyched to have you here to have a very important conversation about that transaction piece of it and how to prepare for the transaction. What should your expectations be? What are the blind spots, pitfalls, best practices? I know you're the man, you're my guy. I know we're going to unpack that, but first I just want to tell just a little bit of a story around you. I'm going to give you a little bit of background here for our listeners. I always feel like I get more out of a message when I feel like I know the messenger a little bit. So fun fact, John and I have known each other for, I don't know, John, about 25 years or more, frankly. I think it's like 25 years. And John first started in our practice as a patient. I remember an early conversation that I had with John once we get to know each other straight away. I was like, if you're going to be my attorney, listen, you need to be under regular chiropractic care. And I say this to my accountant, to my attorney, to my brokers. And I was like, if anybody's going to be advising me, they're going to be doing it subluxation free, right? So John, world-class chiropractic patient, awesome guy, and a fantastic attorney. We appreciate you bringing your wisdom, your expertise to this call.
Yeah, and just one quick Dr. Stephen story. I remember when I started, I said, I feel great, doctor. He said, yeah, it's like falling out of a 12-story building. The first 11 stories are awesome. It's that last story that'll get you, and you got to get started now. So we did.
Well, I appreciate the fact that you trusted me and listened. And I don't want to take any credit for changing the trajectory of your health, for you and your family. But I think it was a bit of an upswing, at least through our great chiropractic care and our influence. I know your family has embraced the wellness lifestyle ever since.
Yeah, we did. So thanks.
All right, my man. So let's talk exit. So, as you hear the framing around those 5 phases, when we talk about the vision, what does success look like to you? What comes to mind to you as an attorney? Like you're on the other side of this, like you're usually, pretty far down the process, if you will. If you had your druthers and you could start with somebody from the beginning as the attorney, sort of that begin with the end in mind type of conversation, what's some of the advice you'd give to these doctors that are listening right now, whether they're 1 year away from selling their business or 25 years away from selling their business? Bring some insight as to your experience and being like, oh man, it's never too early to start this visualization process and beginning with the end in mind.
Right. That's a great way to start. I mean, I tell everybody, I do get to help people start a lot of chiropractic practices and other practices. And you always have to start with the end in mind, just like you said. It's everyone is going to leave the practice one way or the other at some point in time. And so keeping that top of mind is great. So it starts with how you're going to set it up. You can set up the company as a limited liability company. You could set it up as a C corporation. You can set it up as an S corporation. All of those mean different things when you go to sell the practice down the road. My preference, if I had a blank slate, if someone came in, is to set them up as a limited liability company. And the reason for that is it's extremely flexible. If you're a limited liability company, there's not a lot of formalities that have to be taken. You don't need a lot of board votes. You don't need a lot of structure. And also, you can be taxed a lot of different ways. So you can be taxed as an S Corp, a C Corp, or a partnership. And it just provides a lot of flexibility. So if I was going to talk to someone about how to start, that would be my number one piece of advice. My second piece of advice would be always look at everything you're doing as if you're a person walking into the practice knowing nothing about your practice. So, theoretically, when you sell, you'll either have a transition period or you'll be gone, and people need to know how it operates. So documenting everything right from the beginning just helps out a lot. How do you do receivables? How do you set up your patient appointments? How do you do everything? Just documenting from the beginning. So
oh man, you're singing my song there, John. The concept of like capturing all of your processes and your procedures, your SOP, your standard operating procedures into manuals. So many doctors, whether they're 5 years in or 55 years into practice, you're like, okay, so do you have all of your processes and procedures organized? They're like, oh yeah, no, we have processes. I'm like, may I look at your manuals and are they accurate and current? And they're like, manuals, what are you talking about? Or yeah, there's probably a 3-ring binder around here somewhere, and it's been 12 years since, somebody's gone into that. And that can become a massive project, right? So we're just encouraging everybody all along to just recognize that when somebody comes in to buy your business, your job as the seller is to sell your business, right? So practices aren't bought, they're sold, right? So you've got to be able to sell your business. You got to make your business more attractive to a buyer. If you keep that as a mindset as you are putting together your exit strategies, like the big idea is to make your business more attractive to buyers, right? So, well, how do you do that? Well, at the end of the day, buyers are coming in and what they want to do is they want to buy cash flow, number one. Number two, they want to reduce risk, right? So ensure my success, and reduce my risk. And this is one way to reduce my risk is like, hey, listen, you've got a proven system around here. This thing's working. I just want to reproduce your system, right? So being able to delegate to team members, et cetera, right? So that requires the processes and procedures, right? They're going to want to see your financial reporting, right? So and the due diligence around that sort of thing is like, they want to know that they're buying your business and that because they're choosing your business to buy, they're actually reducing the risk of like de novo, right? Starting something on their own. They're buying a business that already has patients, that already has a client list, that already has revenues and profit and a physical space and a team and processes, procedures. You got to think about all these things as you are increasing the readiness of your practice for sale. So I'm glad that you went there, John. So, when we talk about the readiness, what else would you think from the readiness perspective, phase 2, like as an attorney, looking back is like, what are some of the factors from a high level, what are some of the factors that you would consider, indicators of somebody's readiness, whether it's their personal readiness, the practice's readiness, and the difference between a practice and a business, the business's readiness. Like, what are some of the things that you're like, oh man, if I were to speak into this doctor who's going to be selling in 3 years to 5 years, here are some of the things that you should do from a legal perspective, as an attorney's perspective, that, with your experience in these deals, that, you wish you could go back in time and tell these clients, man, 3 to 5 years ago, you should have done this to increase your readiness.
Right. So from a legal point, for perspective, it's just what you said, Doc. It's basically, they want to come in and replicate your success, right? They're buying you because you're successful and they want to replicate that. And if it's all in your head and not anywhere else, it makes it difficult. So on the legal aspect, that means contracts and agreements with a lot of folks, right? So the folks that provide services to you, maybe you have other chiropractors or other staff, you might want to document, your relationship through a contract, an independent contractor agreement, an employment agreement, things like that. It's always important to a buyer that there's confidentiality and that folks aren't going to try to solicit all the patients if they come in and purchase a practice and the current staff and people are not happy with the new arrangement. So non-solicitation agreements right from the beginning, hey, look, you come work here, but if you leave, the patients typically stay with us. Or your agreements with other folks, if you sell supplements, or if you provide any other service, or if you contract with anybody on the outside, you may have a great relationship with them on a handshake. You've been doing business with them for 20 years. I don't even know if I have a fee agreement with Dr. Stephen, but if someone new is coming in, they would like to see a contract. Like, what is your deal with your vendor or your employee or your independent contractor? And they'd like to see it in writing so there's no misunderstandings as to what the relationships are, going forward.
That's exactly right.
Those things are really, those things are key. And one thing, and we're probably getting to this, I'm not sure it's right, here, but when I meet someone who's thinking about selling in 2 or 3 years, I give them the due diligence questionnaire that I know a buyer is going to give you, right? When someone comes to buy your business, they're going to give you a questionnaire that's, 5 pages long, 10 pages long, and they're asking a lot of questions. You just want to answer those before they ask it, really.
Preemptively addressing that, right? So,
Right.
For an example, in due diligence, they want to see your financial reporting, right? So, they're going to want to see back a minimum of a year. 3 years is most likely. It's just like, show me the trending of this business. And I want to see your financial reporting. I want to see the projections. I want to see how you trended against those projections. I want to see the trending of the business in general, top line revenue, profit, et cetera. And I want to see that you have systems in place. I want to see that you have a financial team that understands, how to create not only tax preparation, but strategic reports from a financial perspective for a CEO. Like, that's how I have built it out with I have a fractional CFO who's done beautiful work with us. And I know that the asset value or the enterprise value of our business has grown tremendously because we've made such a commitment to having our financial team in place, our financial reporting systems and meeting rhythms in place. I have total visibility into our business. I can document exactly what's happened in the last 4 or 5 years in our business, which I absolutely could not have done before. And I know that with that would create so much confidence in a buyer, definitely in the seller. And me as a seller, I'm like, listen, this is what this business is, right? So, and this is exactly what this thing's going to do as long as you don't screw it up, right? So, and if you can imagine, if you're a buyer, it's like, wow, that's impressive. I understand what I'm buying, what I'm dealing with. Whereas if you can't produce that, if you can't prove that, now everybody gets a little jumpy, right? So it's just like, especially if you start throwing numbers around, and there's a disparity between what you said from the beginning to what's actually revealed during due diligence, because due diligence is going to happen, right? You're going to have an objective third party that's going to come in and they're going to rip the sheets off, right? There's going to be no secrets. Math don't care, John, right? So it's like, literally, this is what this business is doing. So, you know what? Eat that frog in the beginning, right? So if you can prepare that ahead of time and make sure that you're showing up with some swagger that says, these are the brutal facts of this business. And I anticipated that on the front end, setting that expectation in the agreement accurately, which is going to increase everybody's, confidence in the transaction. Right. Awesome.
So I did a transaction that closed a couple of weeks ago, and the purchase price went down $500,000. And the reason it did was 2 things. One, just as you said, the numbers that were presented initially did not pan out as the numbers that were accurate once they started looking at them. And the second part of it was they would ask for simple things. What are your payables right now? I'll get back to you in a week. What are your receivables? I don't, how many patient no-shows did you have, last week? They couldn't produce anything. And when they did produce them and they checked them, they weren't accurate. It just destroys the confidence of the buyer in the system. So then they have to do more work to make sure they understand what it is that they're buying.
And let me point out what you just said there, John, was the actual business did not change, but the value of that business in the buyer's eyes changed. And it's subjective, right? So there's a nuance to this. If I'm like, I'm losing confidence in this deal, it's like, listen, I'm not going to take on more risk, right? So the price is always going to be a reflection of the risk that the buyer feels like they're taking on. So be prepared on the front end, be totally transparent and accurate. And I would say under promise and over deliver, right? So this is like, listen, set those expectations here and just recognize is like, this is where this thing is, and be conservative in what you're saying so that if there are any surprises, which this shouldn't be, frankly, it's math, right? There aren't any surprises. And that just simply builds the confidence with you. What you just said was, there was a $500,000 swing in a price. That's a ton of money, right? So
Right.
I like to say every $100,000 helps, right? So
Right.
it's like literally, I mean, this is real money we're talking about, right? So, and all of that has to do with preparation. When we work with our coaching clients in this process, we make sure that they're doing like everything you've listed so far. I feel really good about this conversation, by the way, John. Thank you. Everything you've listed so far is part of our process of readiness. It's like, no surprises. Let's get all this ready and we will help you do it. Like you don't have to feel like, oh my gosh, there's so much work to do. Yes, there's work to do, but you want to do that work on the front end, on your toes, proactively, and drive your enterprise value and therefore your price point up, right? Not doing it reactively as they chip away at your asking price, because it's going to happen.
Right. And part of that too is, as you say, explaining when there's an issue, there's going to be, no one's business is perfect.
Right.
So, last March, your revenue went down by 25%. What happened? Point it out. Look, last March, we had a bad month. The chiropractor that was working with us got COVID and couldn't service any of the patients. We couldn't have anybody come in we weren't able to get someone to replace him. So the revenue went down. To tell them the problem, tell them why, and tell them what you did to fix it. That's all you need to do. That wouldn't even result in a change in the purchase price. That would just be, I have confidence the guy saw what was a problem, he addressed it, or she addressed it, and we move forward.
Good. That's exactly right. So, as we move into this third phase, when we go to market, there's obviously the preparation to go to market, right? So help us understand what that looks like. And, again, magic wand opportunity here, John, as the attorney, how would you have your people best prepare? Like, what are the components of that? What does that look like? And then we can talk about the actual, going to market process itself. Like what do you do? What do you need to do from a legal perspective to be best prepared to go to market with your business before you find yourself in a boardroom?
Right. And so, one of the things we like to do is look at all of the agreements, the agreements I said you should have in place, because there's a variety of agreements, right? In addition to the ones I talked to, there are leases with your equipment and with your, maybe with your landlord,
your facility, your equipment,
your
correct?
Facility,
yeah.
Equipment, all of those things. Some of them, right? So we're going to talk probably, I assume, later about, asset purchase versus stock purchase. Even if it's a stock purchase where you don't have to assign any contracts, right? Because the company stays the same. We'll talk about that. But there could be clauses in there that say if you sell most of your stock, the other party to the contract has to approve that sale of stock. And if you do an asset sale, you're going to have to assign all the contracts to the buyer. So looking at the contracts in advance, making sure they have easy assignment provisions. Most people aren't really tied up on the most parties to a contract aren't upset about assignment contract provisions if they're clear. What happens if I want to assign it? And most people do assign it eventually, but making those agreements easy to assign or easy to transfer to a buyer, you can do that in advance. Every time you negotiate, you have leverage, and especially if they're a vendor or they're a landlord, make it a provision that's easy on a sale. Those are things that pop up later. Make sure all your insurances are in place and up to date. You have the right amount of insurance, and it covers the right amount of things, because a buyer will come in and they're worried about liability. If you have insurance in place with adequate coverage that's been in place for the whole time, that's another worry they don't have to be concerned about going down the road. And then, if you're a corporation, making sure you have your board minutes and your shareholder minutes, just the basic blocks of having an organization, all done is good. I went to sell a business a few weeks ago. They hadn't filed 4 years of annual reports, so they were almost dissolved. And so the first thing we had to do, before the buyer saw, discovered this, is file all the annual reports and then, say, oh, this, tell the buyer what happened and it wasn't an issue. But if they discover
Well,
something
that's
like
that's good news, bad news to a lot of our listeners right now, John, because you just covered, that was a holy crap moment for a lot of people that are listening now, because they're distracted me like corporate minutes submit. like I know my listeners, and I know that unless they had somebody else that was delegated to do that, they're like, oh, that's good. And that's the bad news. The good news is you can actually do those in the rears and get caught up on that sort of thing. This is just this is all sort of part of the preparation process to get ready. So, and with some of those agreements, some of the most important agreements, in addition to lease, equipment leases and the vendors and your insurance, et cetera. So think about the employees as well, like your team members, thinking about some of those key players, the office manager, the COO, if you have one, the CMO, the marketing person, if you have one, and associates and associate doctors. Like there's a whole quagmire there of like, the truth is your business is your team and your team is your business, right? So you want to button that up. So we work closely with our clients to make sure that they've got all of those relationships secured, with expectations and agreements, because there's a massive value difference in a business that comes with, let's say, an office manager and an associate doctor or two in place versus, hey, yeah, no, I'm not sure who's sticking around here, but as soon as, word gets out, I'm selling the practice. You may be kind of on your own here, right? So it's like, what am I buying, right? So again, there's things that make the business much, much more attractive to a buyer. So you want to make your business very attractive to a potential buyer. At the end of the day, you want people competing to buy your business, right? So you want to start a horse race where there's 2 or 3 or 4 people competing to buy the business. That's always my goal, right? So, and also make it easy for people to buy your business, right? So those are the 2 things. If you tick both those boxes, it's a win. All right, so let's talk about the transaction piece of it, John. We rock up to a meeting. What needs to be in place? What do we need to be have on the ready? And what should we expect in that transaction, that interaction, for those people who have never sold a business before?
So sort of the process, sort of a little bit, and then
from a high level. From a
really high level. It typically starts with a letter of intent or a memorandum of understanding. That's a document that kind of lays out the principal terms of the deal. This is how much we're going to pay. This is when we're going to pay it. These are the things that are important to us. I mean, it could say something in a letter of intent like, we want Dr. So-and-so, as if she comes with you, if she stays in the transaction, then, we'll buy it. But if she decides she's going to leave, then we're not interested. There could be anything in this letter of intent. And they're very important to me. Make sure your attorney looks at this, whoever he or she is, because a buyer always pitches it. Hey, look, this is non-binding. So don't spend money on a lawyer. Just sign the letter of intent or the memorandum of understanding. It's a non-binding term sheet. Don't worry about it. The truth is, you really have to worry about it, because those are the terms. It's very difficult to change the terms afterwards. You can walk away from the deal. Then it's non-binding in the sense that you cannot go through with the transaction.
Right.
Nobody wants that. But it's very hard to change the purchase price, the type of deal, if it's an asset sale versus a stock sale, the due diligence, the things that are in there that are in the letter of intent, those are difficult to change after they're signed. So it's not non-binding in that sense. So that's the beginning.
It's an incredible dynamic, because, whenever you're sitting down in, I love what Roland Frazier says about this, is like, it's not a negotiation, it's a collaboration, right? So we're trying to solve 2 problems. I'm trying to sell my business. You're trying to buy a business. And if you show up with that what I would consider it, like almost like it's a joint venture. You know what I mean? It's just like, we both want this to happen. Let's show up. Let's define what is the zone of fairness here. Let's operate inside of this thing. We understand, there's going to be objective valuations done on the business. We've already done all of our due diligence and our homework. We know there's a number, right? So your job as the seller is to try to get as much as possible inside of the zone of fairness. And you as the buyer, you're trying to get it for as little as possible inside of the zone of fairness, so that, that's the negotiation, that's the game, right? So there's a collaboration spirit to that. And I love that, to show up with that spirit and be on the ready can actually turn it into a bit of a game, especially if you're dealing with a couple of professionals, and it just keeps a lot of that emotion, out of the situation.
I couldn't agree more. I mean, I think I always tell people when we start the process, it's not like on Succession or one of these other shows. Like that's not how these are really collaborations. Once you decide what the price and the terms are, everybody's just driving toward the goal of closing this in an efficient way.
That's right.
There's not that much fighting. There really shouldn't be any fighting. There should be some negotiation on key terms. Once those are nailed down, it should be everybody going in the same direction, trying to close this. I've had folks, this isn't why John's wonderful, but I've had folks that were buying a company call me and say, look, we've got to get rid of the attorney. Now this is the buyer. We've got to get rid of the attorney that's representing the seller. Would you be willing to talk to the seller and maybe represent them? Because they're fighting so much over things that it's not necessary to fight over. We can't get the deal done. And we're wondering if, the people that have dealt with my team before, and, we know you'll get it done once we agree on the terms. Would you consider talking to them? And I've actually jumped in and kind of gotten it closed because it's not a fight. And if it is a fight, it's really probably not the best situation because there's a lot of cooperation that has to go on after the closing.
That's right.
It shouldn't really be, a battle to get there.
That's exactly right. I love the spirit of that. So, what's actually passing hands now? So we've got the LOI in place. Yep. So we're going to have a contract that has, terms to it, right? So there's going to be a price and there's going to be terms. Would you speak to some of the examples of terms? Like, think about it in a chiropractic office, like what example of some of the terms, and then there's the timeline, and so probably like post-deal constraints. I mean, give us a sense of like what are the guts of those types of documents?
So I'm going to start with the timeline, then I'll talk to you about the terms a little bit. So it's typically letter of intent, then 30 to 60 days of due diligence, them coming in and looking over all of your books and all of your records. We'll talk about that a little bit in a second. And then it's probably 30 days of document drafting and negotiation. That's typically the purchase agreement, which we'll talk about in a second, employment agreements for both the seller and his team or her team. And then there'll be the actual closing, which typically takes 5 minutes now. It's kind of a letdown after all of this work. It's literally everybody on the phone saying we release signatures. It's really, and then there's post-closing issues, and we'll talk about that in a second. So what the documents look like is after the letter of intent, the terms in the letter of intent are price, obviously, how it's going to be paid. So will it be some type of seller note, or will it be all cash up front? Then another term on price would be earnout. So an earnout is, right now your revenue is $1 million. If you hit the $1 million revenue again next year, we'll pay you another $200,000 on the purchase price. I'm just making up these numbers. Yep. Or it could be based on net income. If your net income is $500,000, if you hit that, or if you have an increase, we'll pay you an additional amount of money. That's an earnout. Those are typical terms relating to price. And then if they're not paying everything up front, how is that done? Typically you'd have a promissory note, which is, another document, and it'd be secured by something, the assets that you're selling or the stock that you're selling would be securing that note. So those are some of the terms. Other terms are, what type of sale is this going to be? And this is probably a good time to talk about it. Would it be an asset sale or a stock sale? And they're very different tax consequences of that. So an asset sale, they're literally coming in and buying your assets, your receivables. They're usually taking on your payables. They're buying all of your equipment. They're buying your goodwill, which is probably your biggest asset, your trademarks, your trade names, and all of that. And you're taxed on that. Some of it is taxed as a capital gain. Some of it is taxed as ordinary income. So buying your receivables, that's ordinary income. Buying any equipment that's been depreciated, all of the depreciation is going to be ordinary income to you. They call it depreciation recapture. If you have any inventory of anything like supplements or something else that you might sell, that's all ordinary income when you sell the inventory. And then other things like goodwill will be treated as a capital gain. That's an asset sale. You literally transfer your assets through a bill of sale to a buyer. A stock sale is a little different. Stock sale is you're literally selling, or an equity sale, you're literally selling the membership interest in the LLC, the stock in your business, that type of thing. And that has different tax consequences too. If you sell the stock in your business, typically that's capital gain, all of it.
Right.
So the entire purchase price would be a capital gain. And that's really what you would like to do. If you're an S Corp or a C Corp, you definitely want to sell stock, would be your preference.
But if you're an LLC, is there a preference one way or the other?
There's a bit of a preference. If you're taxed as a partnership, it ends up being pretty close to the same tax-wise either way. It's a little easier,
because it's a flow through. Is that what that?
Because it's a partnership, they basically usually step up the assets. It's like you're selling assets.
Yeah. Okay.
For tax purposes.
Okay.
And if I could just get into the weeds, one more part of this, you could sell your stock, but the buyer elects to have it treated as an asset sale. It's called a 338H10 election or a 338E election. And so you get the benefit of selling your stock, so it's easier to do. You don't have to have bills of sale and signing contracts, but your taxes if you sold your assets. So that's why it's important to have a lawyer look at your letter of intent. I did a deal a little while ago, and the guy came in and said, "Hey, look, got the LOI. Can you help me out? Help me close." He said, "It's a stock deal. This is awesome. It's going to be great." And I look, and there's one line in there that said, the buyer will make a 338H10 election, period. That's all it said. Well, that means it's really an asset sale for tax purposes. And it's had a big financial impact because there's a big, the tax difference between.
So if you're selling your business, you're the seller, you sell your business as an asset sale, there's going to be a mixture of capital gains and regular income, right? So, and then if you're selling it as a stock sale or an equity sale, it's much like if you said, "Hey, I own 100% of the stock of this business. I own the business." You're buying 100% of the stock of the business. It'd be a capital gains for the seller in a stock sale.
Right.
Yeah. Very good. Very good.
With that one caveat that they could elect a stock sale to be taxed as an asset sale. So you have to watch for that.
Okay. What are your pros and cons on the owner seller financing, and how do you protect yourself on that?
So, as long I don't typically have, so the pros are, it usually helps a deal immensely because it's that equity part that makes financing possible in a lot of situations. That's the pro. So it makes the transaction easier to accomplish and makes it easier to sell. And typically you might get a little bit of a higher price because they value the fact that you are doing some seller financing.
Yeah. And you have skin in the game, right? You can be sticking around, and it's just like, listen, I believe in this business. I believe in you as the buyer. I'm going to stick around. The last thing I want to happen is this to fail. Right. So it's like so many docs.
Our interests are aligned, so
this is the hard easy. If you try to do this, easy on the front end and make it too easy, it's going to be hard for you in the process of, trying to get paid out over 5 years or what have you. So, do the hard work on the front end, and do your due diligence. Right.
Right. The con is typically, you could secure that with either the shares that you've sold or the assets, but most of the time there's other financing, and you'll be behind that other financing almost every time. If there's a bank financing involved, you would be second in line to the bank. It's called subordination. You'd be subordinated to the bank. So the bank gets paid first, you would get paid second. So it's a little bit trickier. It's a little trickier to do.
Understood. And are those funds escrowed, or how do they release funds? Like what does that look like?
So on the seller financing, so typically, we would have a promissory note, and they would pay it over time. You wouldn't want to have, I think what you're talking about, sometimes there's a seller holdback. They just say, "Hey, look, we're paying you 80% now, and in a year we'll pay you the other 20%. You don't want to have that because it's not very well documented or secured. You want to have an actual promissory note for the amount that's the seller financing, and you want it secured through a security agreement on the assets of the business.
Okay, very good. So last question on the last phase is transition. So now it's post-sale. What have you seen as an attorney? Like, again, speaking, let's go upstream, let's go back 5 years, 3 years, 2 years, before you sold. Like, what do they need to be thinking about? What are the considerations? What are the blind spots, even from a legal side? Everything from maybe this tax strategies that they want to be aware of. Maybe there's career paths they need to be thinking about, or even personal identity issues. And I know I'm throwing the kitchen sink at you with that question, but it's like, what have you seen just as their, confidant, their attorney?
Yeah, I mean, I'm going to start with the personal issues first. A few years ago, I did a closing where the person's spouse showed up at the closing, and I said, "Oh, it's and nice to meet you." It was the fellow's wife, and I said, "Nice to meet you. Thanks. I don't normally see folks come to the closing." She said, "I want to make sure he signs these documents because he's been saying that he's going to sell this business for 20 years. He was like 75 or those days."
She was the heavy.
She said, "I want this. I want him to sell." He wasn't able to let go. It was a professional services, but not a chiropractor. He wasn't able to let go of his identity as the profession that he was in. And so, it is something to think about. I found that they need to have something else that they're going to focus on after closing. There's going to be a transition period. They're going to want the seller to stay no matter what for 6 months or a year.
Or 6 weeks. Yeah, there'll be something. Yeah.
6 weeks. And if it's an internal sale to your own employees, they want you gone as quickly as possible because
yes,
you're looming over the business, and right. The faster you're in and out. But I found that they're most satisfied when they have something else they want to do, a charity, a different business, a hobby if they have one that they're very strong about. But you have to think about it ahead of time. I've had people be very unhappy after selling because they just didn't feel like they had a purpose any longer, or their identity was gone. So it is something to think about.
So from a personal side, John, so I can remember, you were our attorney when we sold our practice, when we sold our business. And I remember you taking me aside and saying, Dr. Stephen, I'm worried about you. And, it's like, are you just going to go fishing now, or are you going to, I'm kidding, John. John knew what I was up to. Are you going to go home and sit and twiddle your thumbs and just go surfing, or right. No? It was really, I think it's an important question. Is like, what are you doing that's going to be fulfilling and challenging and be purpose driven on the other side of it? And that might be like what we did, started the Remarkable Practice, right? So we had we have since started a portfolio of businesses that all serve chiropractic. It's just like, we were clear on what we were doing and why we were doing it. So there was no question there. Your big why might be, hey, I want to, I miss too much time with my kids. I want to spend time with my grandkids, and I'm going to be, super grampy or grandma, it's just like, this is what I'm going to do. Or I'm going to, hey, I'm going to start a foundation or a charity, or I'm going to do charitable work, or work at my church, or, I'm going to become a coach, or I'm going to, run a podcast, or I'm going to start another business, whatever it is, but to have that next chapter, mentality around it. And even your role, you might stick around in the practice and your role might change in the business, right? So it may be, you're actually going to stick around, and the things switch. Now you're, instead of being the owner with an associate doctor, now maybe you are the associate. And for some people, they might not consider that palatable at first, but it's like, okay, so you're the celebrity adjuster that comes in 4 shifts a week, right? So and there's a whole nother chapter. There's so many tracks, there's so many opportunities that I just want to open up the doctors' minds, the owners' minds, that, I know so many people have their identity just tied up in, serving patients, which was probably a big key to your success. But the reality is that you don't have to leave that entirely. That may be an option for you, or there may be a way for you to actually scale all of that knowledge and wisdom and experience and continue to serve the mission either inside or outside of chiropractic.
Yeah, I mean, my experience has been with all professions, but particularly something that's so personal like chiropractic, that if you wanted to stay, the buyers typically are fine with that. I just did optometrists. I sold an optometrist practice, and what their big issue was, they were in their late 60s. They wanted there's two optometrists. They wanted to keep working for 3 years, but they wanted to scale down. They wanted to work full time and then drop down to a certain amount, and just they wanted to have a gradual decrease so that they weren't jumping off the gerbil wheel to nothing and losing all of their relationships with their patients and all of that. And buyer was fine with that. They thought it was a great thing to do, and it was right in the agreement.
Yeah, there's so much to be said for like a soft landing and a runway, from, full time to 2/3 time to 1/3 time to out, and whatever that runway looks like. We've seen that just done so successfully. How about tax strategies? Now, now you're sitting there and you got a check in your hand, right? So it's good news, bad news, of course. Uncle Sam is very happy also and wants to play along, he wants to be at the party. What are some of the things, it's not just about getting, the highest asking price because you've increased enterprise value and, now you're the winner because you've cut this check. What are some of the tax strategies that you could put in place 3 years back, 5 years back, 1 year back, whatever it is, John, that would help you keep as much as possible, like in your pocket and still sleep at night?
Right. I mean, it's hard to do income tax planning. It's really, there's not a ton that you can do there, but what you can do is on estate tax planning, for the real future. What a lot of clients will do is either sell or gift their interest in the business to an irrevocable trust. So if you do that, say you gift it in there at a value of 500,000, and when you sell it, it's $1.5 million. That additional $1 million is not in your estate for estate tax purposes. And, some states have pretty high estate taxes, and the federal government, who knows what these lunatics are going to do. Right now, it's dropping to the estate tax credit is very high right now, but it's going to drop down to $5 million at the end of 2025, each person. And it may even be adjusted, another way, depending on who's in charge. But it's really state taxes you can save by doing something like that, trying to structure it in a way. So that typically, or if it's possible and you have family members that are eligible to be licensed and owners of the business, you can, fractionalize the ownership so that it's sold, different folks get the proceeds. But there's
That's
not
right.
a ton that you can do, beforehand on the income tax side. It's just difficult.
On the income tax, right?
Yeah.
Some structural. And I know that I'm asking you, that's a tough question because there's so many details around that, like in every state and every case is so different. And, the reality is that there's enough layers to this, and there are some opportunities that we can get creative with. But that's why you guys get the big bucks, right? That's what attorneys are for. At least that's the way I justify it, John. So, all right, my friend, anything else that we need to know, like any other pitfalls, blind spots, any words of wisdom to wrap up this process to, create truly, your ideal exit, which we call the remarkable exit? Anything from your perspective that you'd like to leave these doctors with?
Yeah, I've got one nuts and bolts one and then one bigger picture one. So the one nuts and bolts one is that, and I haven't mentioned it so far, is at the closing, the buyer is going to be worried about liabilities. If they buy the stock, they're taking on all of your liabilities from the beginning of time until now. And if they buy your assets, there's certain other liabilities. So they're going to ask you to make representations and warranties in this agreement. You're going to make a representation like, we have no employment claims. I've got no, professional malpractice claims, or listing what they are. And what they're going to ask you to do is hold back some money for that. It's likely that they're going to say, hold back 10% of the purchase price for a year or 2 years, just to make sure nothing pops out of the woodwork. So I just wanted to mention that because sometimes it comes as a surprise at the closing.
Out of left field.
Out of left field, that I have to hold back some money. If you have a note, usually you can offset the note that they already owe you money. They can offset that. That's fine. But
I consider it, just think of it as an insurance policy for the buyer. It's just like they're taking out a little insurance on it. It's like, I love the law of price and terms. It's like, okay, your price, my terms. One of the terms is I'm going to hold back 10%, and that's my insurance policy. Make sure I don't get, something, so skeletons in the closet, right? So literally and figuratively.
And it almost never gets, I've had claims on it. I mean, maybe 2 or 3 times in 30 years have I had claims on those escrows. It's just a way of making sure that if something goes wrong, there's something there. And then the bigger picture is, you really have to talk to folks like Dr. Steven and others. What really is the value of your practice? I can tell you that on the sales, two things. The main issue is that sometimes people believe their business is worth more than it is. And it becomes a challenge, because if everybody says your business isn't worth that, it's not. And people have an amount in mind because that's what they need to retire or to move to the next stage in their life. But that doesn't always line up with the value of the business. So you have to just be objective about what the value of your business is, and listen to what everybody's telling you. Listen to what prospective buyers are telling you. Listen to what people like Dr. Steven are. If you use a broker or something, listen to them, and be open-minded about what the practice is worth, because it's only worth what a willing buyer and a willing seller are willing to agree on. There's no fixed amount that is. So.
It's great wisdom, John, and it's really what it all comes down to, right? At the end of the day, it's a math problem, okay? And we love to say math don't care, right? So the reality is there are objective ways to measure this business, and you want to be high data, low emotion, in this scenario, right? So it's just like, you want to keep the emotion out of it. When we work with our coaching clients in the Remarkable Exit program, taking them through this process, we're very clear with them. It's like, listen, there's an objective value for your business as it stands today. Let's determine what that is. Okay. So here's the value, right? This is what would be considered fair market value. And there's going to be a range, right? And now we get to work, and there's an opportunity for us to increase the enterprise value of your business. And that's the work that we do with them, right? So we actually take them through these 5 phases. We have a 21-step checklist for them to go through. We have these value drivers that, it was great because you mentioned so many of the things that we do to tighten up the bolts, clean it up, right? So, and just like if you're going to sell your home, there's things that you can do to increase that curb value and curb appeal and the value of the home and what have you. And you want to do that proactively, and it takes time to do that. And we both know the expression, when's the best time to plant an oak tree? 50 years ago. When's the next best time? Today, right? So, you said it already. We all have to exit, right? So it's death, taxes, and exiting, right? At some point, we all exit, whether you are 1 year away from wanting to do that, or 5 years, or 15 years, or 30 years away. Just listen to us when we say this. It's like, build it to sell it, right? Begin with the end in mind, and you'll never regret owning a business that you built to sell. It's going to be more productive. It's going to be more profitable. And frankly, it's a lot more fun to run that business, right? So John Colucci, my attorney, our Remarkable Exit expert for the Remarkable Practice. John, I appreciate you, man.
Hey, thanks. Thanks for having me on. It was a lot of fun.
Thanks for listening to this episode of the Remarkable CEO Podcast. Remember, what the world needs now is chiropractic. And what chiropractic needs now is more successful chiropractors. If you like this podcast, please subscribe, share with a friend, and leave us a review. And if you'd like to connect with us personally, direct message us on Facebook, LinkedIn, or Instagram. Now go and be remarkable.